Miscellaneous Fees and Levies Act, the Kenya Revenue Authority Act, the Retirement Benefits Act, the Alcoholic Drinks Control Act of 2010, the Special Economic Zones Act, and the Export Processing Zones Act. The National Assembly Standing Orders 132 and 133 permit amendments to be made to a bill during the committee stage. And we have cited again the case of Pevans, East Africa, the decision of the Court of Appeal in that matter, where the court affirmed the position that Parliament has the power during the legislative process to make changes to a bill post-public participation. And I think it's important that I read this passage. It must be appreciated that after the National Assembly has heard the views of members of public and industry stakeholders on a bill, it is not precluded from effecting amendments to the bill before finally passing it. These amendments do not necessarily have to agree with the views expressed by the people who have been heard, so long as the views have been taken into account. In our view, it would bring the legislative process to a complete halt and undermine Parliament's ability to discharge its constitutional mandate if, after having facilitated public participation on a bill, Parliament is required to adjourn its proceedings every time a member proposes an amendment to the bill so that further public participation can take place on the particular proposed amendment. End of quote. By its nature, public participation is intended to explore new issues that may be raised, interrogate, and understand existing ones, which may lead to revision or refinement of the bill through new proposals and amendments. We are bound by the holding in Pevans case, which I have read from, that once the National Assembly has heard the views of the general public and the stakeholders on the bill, it is not precluded from effecting amendments to the bill during debate before it is passed, as a contrary position would amount to curtailing the legislative mandate of the National Assembly. The National Assembly was not required, therefore, to submit the amendments complained of to public participation on narrow issues that were within what was contemplated within the objects and memorandum of the bill. Having considered the relevant facts and the record, and bearing in mind that the finance bill is a time-bound legislation, we are satisfied that the public participation process conducted by the National Assembly was sufficient. I will now move to the third issue, which is whether certain taxes cited in the, whether certain taxes cited in the petition as enacted by the Finance Act are unconstitutional. The petitioners challenge tax-raising measures introduced by the Finance Act. We will resolve them in light of the applicable constitutional provisions. Under Article 94, Sub-Article 1 of the Constitution, the legislative authority of the Republic is derived from the people and vested in Parliament. Correspondingly, Article 210, Sub-Article 1, provides that no tax or licensing fee may be imposed, waived, or varied except as provided by legislation. The power to impose taxes by the national government is provided for in Article 209 of the Constitution, and we have cited the entire provision. And the totality of the aforesaid provisions is that the legislature, in this case the National Assembly, has broad powers to levy tax, so long as the power is not exercised in a manner that infringes or violates provisions of the Constitution, more particularly the process prescribed under the Bill of Rights. Tax laws are not enacted in a vacuum. They are the product of a process which is recognized by the Constitution. Upon formulation of policies underpinning the revenue and expenditure by government, the legal process commences with the National Treasury preparing a budget policy statement and submitting it to the Cabinet for approval pursuant to the Public Finance Management Act. This culminates in presentation of the estimates of revenue and estimates of expenditure and the budget to the National Assembly for consideration and enactment of the Appropriations Act under Article 220 and 221 of the Constitution. Revenue-raising measures are provided for in the Finance Act, which is a money bill recognized by Article 114 of the Constitution. In view of the merger of policy and legislation, as reflected in many judicial discretions, Courts have been slow to interfere with tax legislation. We cite here the case of in the state of MP versus Rakesh Kohli and another. It's a decision of the Supreme Court of India. It's a brief one, I'll just read for us. While dealing with the constitutional validity of a taxation law enacted by Parliament or state legislature, the court must have regard to the following principles. 1, there is always a presumption in favor of constitutionality of a law made by Parliament or a state legislature. 2, no enactment can be struck down by just saying that it is arbitrary or unreasonable or irrational, but some constitutional infirmity has to be found. 3, the court is not concerned with the wisdom or lack of it, the justice or injustice of the law, as the Parliament and state legislatures are supposed to be alive to the needs of the people whom they represent, and they are the best judge of the community by whose suffrage they came into existence. 4, hardship is not relevant in pronouncing on the constitutional validity of a fiscal statute or economic law. And 5, in the field of taxation, the legislature enjoys greater latitude for classification. The respondents argued that the court should not intervene in tax issues because these are policy matters. This approach is correct to a certain extent, as exemplified by Odunga J. in Waweru and 3 others, versus the National Assembly. I do not need to read that, but we have cited the passage from his judgment. On the other hand, the court has a constitutional duty under Article 165, Sub-Article 3b, D, and D, Roman 1 and 2, to determine the question whether a right of fundamental freedom in the Bill of Rights has been denied, violated, infringed, or threatened, and whether any law is inconsistent with or in contravention of the Constitution, and the question whether anything said to be done, to be done under the authority of this Constitution or any other law is inconsistent with or in contravention of the Constitution. By these provisions, neither laws nor policies are immune from the scrutiny of the court. And in the Nubian Rights Forum, and 2 others versus the Attorney General, the court echoed this position by stating that anything done by Parliament outside the confines of the Constitution and the law attracts the attention and action of this court. In conducting an inquiry into the constitutionality of the decisions and actions of the legislature, the court finds constitutional authority in Article 165, 3d. The thrust of the respondent's response to the petitioner's case is that the legislature has the power and authority to impose taxes. This power is not unconstrained. It is constrained within the 4 corners of the Constitution. Parliament cannot exercise its power in an arbitrary fashion without any rational connection to a legitimate purpose. To permit the legislature to assert a contrary position would undermine the national values of and principles of the rule of law, good governance, accountability, and transparency. Turning now to the taxes challenged, the petitioners attacked Section 2 as read with Section 21 of the Finance Act for amending Section 35 of the Income Tax Act as unconstitutional for imposing taxes on entertainment, which is a function of the county government under Part 2.4 of the 4th schedule of the Constitution. Digital monetization is introduced in Section 2 as a tax on payments for entertainment, social, literal, etc., through any medium or channel. Such payment is treated as income, and a person paying a non-resident or a person not having a permanent establishment is required to pay withholding tax on the payment. The purpose of the amendment here is to clarify the type of income to be taxed. It is a tax on income which the national government is authorized to impose pursuant to Article 2091, Sub-Article A of the Constitution. This does not affect the powers and functions of the county governments as contended by the petitioners. Similarly, digital asset tax introduced by Section 2 is payable by a person on income derived from the transfer or exchange of digital assets, for example, cryptocurrency. This is a tax on income, and the manner in which it is charged and collected is within the purview of Article 209, Sub-Article 1A of the Constitution. The petitioners also challenged the Finance Act on the ground that it includes tax on winnings from betting, gaming, and lotteries, which they contend violates the 4th Schedule, Part 2 of the 4th Schedule of the Constitution, in that betting, casinos, gambling, and gambling fall within the powers and functions of the county government. The Finance Act amends Section 2 of the Income Tax Act to define winnings as a payout from a betting, gaming, lottery, prize competition, gambling, or similar transaction under the Betting, Lotteries, and Gaming Act, excluding the amount staked or wagered in that transaction. This section is to be read with Section 10 of the Income Tax Act, Section 10 of the Income Tax Act, which states that winnings constitute income accrued in or derived from Kenya and are subject to income tax. The purpose of this amendment, to our view, was to clarify the definition of the term winnings. This is plainly income, a matter of income within Article 209, Sub-Article 1A, and does not affect the powers and functions of the county government, as was held in Pevan's case. The petitioner, in petition E211 of 2023, challenged the proposal in the Finance Bill seeking to raise the entry point of eligibility of businesses for payment of gross turnover tax from a sum of 1 million shillings to Kenya shillings 500,000. Upon our perusal of the Finance Act, we found that this proposed amendment was not enacted. Section 26 of the Finance Act amended the 3rd Schedule of the Income Tax Act to introduce new tax bands. In addition, Section 7 of the Act amended Section 10 of the Income Tax Act relating to withholding tax. The petitioners have not demonstrated how these amendments affect specific provisions of the Constitution. In any event, we hold that these are matters related to tax policy and administration. Section 33 of the Finance Act amended Section 17 of the VAT Act to introduce 16% VAT on insurance compensation. The petitioners argued that insurance compensation is not income and is therefore not subject to taxation, and further that the provision amounts to expropriation of property in violation of Article 40 of the Constitution. We hold that imposition and collection of tax by legislation does not of itself constitute a violation of the right to hold or own property, and here we cite the case of George Lesaloi Selelo and another versus the Commissioner General. This amendment, the amendment that is by Section 33, only applies to persons who had claimed input VAT on supplies or services and who subsequently receive compensation, which includes VAT, and are therefore required by the amendment to declare the VAT component. This, too, is a tax administrative measure and does not violate Article 40 of the Constitution. The petitioners equally challenged Part 2, that is Sections 30 to 38 of the Finance Act, which amended Sections 5, 8, 12, 17, 31, 34, 43, the 1st and 2nd Schedule of the VAT Act. These provisions impose, vary, or remove VAT on specific goods and services. They also vary the VAT rates applicable and the manner VAT is administered. We hold that these are matters within the competence of the legislature and reflect the policy choices of the national government. And the petitioners, to our mind, have not shown how these provisions violate the Constitution. Moving on to Part 4 of the Finance Act, which contains Section 40 to 48, which introduced amendments to Section 2, 20, 28, 40, the 1st and 2nd Schedules, and added Sections 36(1)A and 36(a) to the Excise Duty Act. We say that excise duty is a tax on the sale and importation of specific goods and services. The amendments introduced the requirement for remittance of excise duty on betting and gaming within 24 hours of closure of a transaction, as well as remittance of excise duty on alcoholic beverages within 24 hours of removal of the goods from the stockroom. The petitioner's complaint is that the requirement is unreasonable. We find that this is a tax administration measure designed to ensure that excise duty is collected and accounted for. We do not find any justification to intervene in that matter. Other grounds upon which the respondent assailed the excise duty relate to changes in tariff headings and rates of taxation on various products. The petitioners have not shown how these provisions violate the Constitution. We therefore hold that these changes are governed by policy and do not violate the Constitution. The petitioner in petition E2 211 of 2023 challenged excise duty imposed on human hair, wigs, false beards, eyebrows, eyelashes, and artificial nails in respect of the finance bill. You can see I'm smiling. However, this provision did not see the light of day and was not enacted into the Finance Act and is therefore a non-issue. Thank you.
I shall now read the second last issue, which is whether the Section 84 of the Finance Act 2023, introducing the housing levy, is unconstitutional. The petitioner's grievances against the introduction of the housing levy are varied and include the following: that will be judges, members of constitutional commissions, and holders of independent offices will be affected in contravention of the Constitution, that there was a lack of a legal framework on the imposition and administration of the levy, contrary to Article 210, that the absence of a foundational statute results in uncertainty, that no fund as envisaged in Article 2061 has been put in place, and that the Constitution places an obligation on the national government to deposit all monies it raises in taxes in the consolidated fund, that KRA's mandate does not include collection of funds arising from the levy, that the provision violates the Housing Act, and that it further violates that the deduction is unconscionable and impractical, that Part 1 of the 4th Schedule to the Constitution limits national government's functions in relation to matters housing, to development of a housing policy, and no more, that public participation in respect of the levy was cosmetic and a mockery of the centrality of the people as a source of authority exercised by the government, that the Employment Act already obligates employers to provide housing for the employees, and that the imposition of the levy amounts to double taxation and is a form of regressive and discriminatory tax that imposes a disproportionate burden on one group of earners without justification, and is therefore a violation of Articles 10, 21.3, 27.3, 201 of the Constitution, that imposition of the tax under the Employment Act, whose right is to secure rights of employees, amounts to a limitation of labor rights, amongst others, and must be justifiable under Article 24 of the Constitution. The respondent's answer to the petitioner's grievances is that the taxation is a prerogative of the national government, that the national government is not seeking to regulate income as a socio-economic activity, but the amendment is aimed at taxation on income, which the national government is empowered to impose, and that establishment of a housing fund is a policy decision aimed at enabling the government to provide adequate housing for all its citizens towards fulfilling the dictates of Article 43, 1B of the Constitution. They further argue that the impugned section enjoys presumption of constitutionality, and that the introduction of the levy is not a novel issue, as there are other levies imposed by the national government that are geared towards collecting funds for various key priority areas, such as the sugar development levy, railway development levy, road maintenance levy, national hospital monies paid to the National Hospital Insurance Fund, the National Social Security Fund, hotel and catering levy, fuel levy, standards levy, and others. They submit that the housing levy will assist the government provide affordable housing and alleviate the housing shortage in this country. Further, the taxation targets certain sectors of the economy, and if sufficiently justified, differentiated treatment is not unconstitutional. The respondents defended the appointment of KRA as an agency of the government for collection of revenue to collect the levy, citing Section 5.1 of the KRA Act and Section 75 of the Public Finance Management Act. Amendments to the Employment Act, and that further amendments had been conceived and were being introduced to create the Housing Levy Fund pursuant to Article 2062. That said, the fund would be distinct from the National Housing Development Fund created by Section 7.3 of the Housing Act, and that these provisions satisfy the prescriptions in Articles 12, 10, 201, 206, and 209 of the regarding legality of tax measures. We now turn to consider the substantial issue raised by the petitioners, whether the amendment of the Employment Act by Section 84 of the Finance Act to create a housing levy or tax in accordance with was in accordance with the constitutional requirements. The effect of the amendment was to add sections 31B and 31C to the Employment Act. The amendment is in three parts. The first part imposes a levy on the employer and the employee. The second part states that states the purpose of and ring fences it, while the third part imposes on the employer the obligation to deduct, collect, and remit the levy, and provides a sanction for non-compliance, and we have set it out in full. The petitioner argued that the housing levy is not a tax contemplated under Article 209 of the Constitution. The amendment does not contain a legal definition of the housing levy, nor even define the term levy as used in that amendment. This lack of uncertainty is a matter of importance, is a matter as important as the definition of the housing levy is a major defect in the impugned amendment. One of the distinguishing features of the other existing levy that was cited by the respondents in defending the housing levy is that they are anchored in comprehensive acts of parliament that include definitions of subject levies. Other tax legislation, such as the Income Tax, VAT Act, Excise Duty Act, contain definitions of the taxes imposed therein. The petitioners also pointed out that the definition of employee contained in the amendment does not distinguish between local and foreign employees. Although the Constitution does not use the term levy, a levy is for all intents and purposes a form of tax. According to Black's Law Dictionary, a levy is the imposition of a fine or a tax, the fine or tax imposed, and to impose or assess a tax or fine by a legal authority. Whereas the term tax means a charge, usually monetary, imposed by the government on persons, entities, transactions, or property to yield public revenue. Broadly, this term embraces all government impositions on the person, property, privileges, occupations, and enjoyment of the person, and includes duties, imposts, and excise. The petition argued that the levy is not one of the enumerated taxes in Article 209, A, B, and D of the Constitution. In the absence of a clear definition of a levy within a foundational statutory enactment, it is difficult to confidently associate a levy with the category of taxes envisaged in the foregoing provisions, although on the face of the amendments, it is intended to be levied on income of employees. The uncertainty surrounding the housing levy is compounded by the failure to state the nature of the tax, percentage payable by the employer, is it income tax or a contribution paid by the employer for the benefit of an employee. Under Article 209(2), an Act of Parliament may authorize the national government to impose any other tax or duty except those which the county may impose, which include property rates, entertainment taxes, or any other tax it is authorized to impose by an Act of Parliament. Related to this issue is the question whether imposition of the housing levy is a matter concerning county governments. The petitioners argued that housing development and planning is a function of the county governments under Part 2 of the 4th Schedule. The respondents contend that the levy is part of the housing development policy and Part 1 of the 4th Schedule of the Constitution to support affordable housing. The housing levy is enacted by the Finance Act by way of an amendment to the Employment Act to support the national government policy on affordable housing. It is a tax on income duly authorized by Article 292 of the Constitution. Related to this issue is whether that imposition is a matter concerning county governments, as argued by the petitioners. The housing development and planning is a function of the county government under Part 2 of the 4th Schedule of the Constitution, while the respondents contend that it is underpinned by the power and function of the national government under Part 1 of the 4th Schedule to support affordable housing. The 4th Schedule provides the distribution of functions between the national government and the county governments. Part 1(2) of the 4th Schedule grants the national government authority over housing policy, while Part 2(8) of the same schedule provides provides for county planning and development of housing. Lenaola J. explained the distinction in the housing function between the two levels of government in Law Society of Kenya versus Cabinet Secretary, Ministry of Lands, Housing and Urban Development. He stated that the words housing policy and housing as used in the 4th schedule in respect of the national and county government functions respectively are capable of varied interpretation and application. Black's Law Dictionary defines a house as a home, dwelling or residence, while policy is defined as general principles by which a government is guided in its management of public affairs. A mandate of the national government involves accreditation, regulation, and promotion of quality assurance, technical capacity assistance in the construction industry at large, while the county government is involved in housing to the extent of planning and development within a county only, and there are also other cases we have cited. The distinction between the housing functions between the national government and county government was also considered by the Court of Appeal in Speaker of the National Assembly and others, versus Senate and others. The question in that case was whether contributions to the National Housing Development Fund infringed county government functions, and this is what the Court of Appeal stated. An examination of the Act indicates that notwithstanding the amendments, that the amendments are housing related, the central theme is to establish a National Housing Development Fund into which employer and employee contributions are to be paid, the sums which go towards financing the building of affordable units. Insofar as the enactments concern the imposition of taxes under 209 of the Constitution, which are paid into the National Housing Development Fund, we find the national perspective upon which the housing development policy is founded is not a county function to which Article 103 of the Constitution required to be applied. We agree that housing is a shared responsibility between the national and county governments, where each level of government has a defined role to play. In this case, the purpose of the levy, as stated in the amendment, is to provide funds for the development of affordable housing and associated social and physical infrastructure, as well as provision of affordable home financing to Kenyans. In this case, therefore, the stated purpose of the levy is to support the national policy on housing, and we find that the petitioners have not demonstrated how this policy interferes with the functions of the county government under Part 2 of the 4th schedule. Legal certainty is one of the hallmarks of the rule of law, good governance, transparency, and accountability under Article 10, 2A, B, A, and C of the Constitution. The amendment, in our view, does not, either on its face or by reference to other legislation, show how the stated purpose is to be achieved. It is not open. It is not open to the respondents to supply these details through responses, as they have not sought to do. As they have sought to do. The enactment ought to address these details and speak for itself. Article 210 contemplates a comprehensive taxation law, without which it is virtually impossible to determine whether and how the imposition of the levy will impact the shared function of housing, or whether it will restrict or limit the functions and powers of county government under Part 2 of the 4th schedule, which raises the further issue whether Parliament, as used in 209(2) and 209(3)(c), refers to both houses of Parliament, and whether the Senate ought to have been involved in deliberations relating to that amendment. This is yet another lacuna that the amendment did not address in its definition, resulting in uncertainty. The petitioners challenged the housing levy on ground that it was enacted as an amendment to the Employment Act without a comprehensive legal framework to govern it, in violation of Article 210, national values and principles of governance, in Articles 10, 2A and C, namely rule of law, good governance, and transparency and accountability. They submitted that there is no legal framework for administration of the housing levy, despite the imposition and collection of the levy. They faulted the appointment of KRA as an agent of collection of the levy on the ground that it contravenes Section 5(1) of the Kenya Revenue Authority Act and the first schedule thereto, and hence it is of no legal effect. They contended that without a comprehensive legal framework being put in place, the national government would threaten, undermine, or usurp the functions of county government. That without such a comprehensive legal framework, there would be no guarantees that the functions of county government specified in the constitutions will be respected. The respondents' rebuttals were somewhat mixed. On the one hand, they stated that the housing levy is anchored in the Housing Act, which established the National Housing Development Fund, and in the Employment Act as amended. That an amendment was in the pipeline to anchor the levy and create a fund separate from the Housing Development Fund in the Housing Act in compliance with Article 261. That further, they further asserted that it is the prerogative of the national government to impose taxes aimed at enabling the government to provide adequate housing for all citizens towards fulfilling the right to accessible and adequate housing and to reasonable standards of sanitation provided under Article 43(1)(b) of the Constitution. They reiterated the creation of the housing levy is not novel, as there are other levies by the national government that are geared towards collecting funds for various key priority areas. On the issue of collection of the housing levy, KRA pointed out that under Section 5 of the KRA Act is an agent of the government for purposes of receipt of the national revenue and was duly appointed as such. That under Section 75 of the Public Finance Management Act, KRA is mandated to collect the revenue for the national government. Article 210 provides that no tax or licensing fee may be imposed, waived, or varied except by provided by legislation. In addition, Article 110(2)(b) and (c) applies the national values and principles of governance and has the components of rule of law, good governance, transparency, and accountability, amongst others. The gravamen of the petitioner's case is the housing levy introduced through an amendment of the Employment Act by Section 74 has a number of shortcomings that in our view fall short of the principles of legal certainty, rule of law, good governance, as well as transparency and accountability. Although Section 84(3) of the Finance Act says that the housing levy shall not be used for any other purpose other than development of affordable housing, associated social physical infrastructure, as well as provision of affordable home financing to Kenyans. It is not anchored by a corresponding legal mechanism demonstrating how this objective has been actualized. These are like other levies cited by the respondents, which are collected for a specific purpose and are anchored through a legal framework governing them. Section 84 does not set out how this levy will be administered once it's collected. More importantly, the legislation does not set how it supports the housing policy function of the government. This concern is not idle, as the manner in which money is administered and spent may encroach on the powers and functions of county government. Further, without a framework embedded in legislation, how would members of the public know who are the beneficiaries of the housing levy? What are the requirements for one to benefit? The opaqueness undermines transparency and accountability. And in our view, Section 84 of the Finance Act does not meet the good governance test required under Article 10(2)(a) and (c) of the Constitution in the absence of a clear-cut legal framework concerning administration of these funds. In their submissions, the respondents contend that money collected as housing levy is ring-fenced by the purpose stated under Section 84 of the Finance Act, and that the legal framework supporting the housing levy is provided by the existing National Housing Development Fund established under the Housing Fund. An ex parte examination of Section 84 of the Finance Act does not in any way show any connection between the housing levy and the National Housing Development Fund. Our concern is that under Article 206 of the Constitution, all money is raised or received by or on behalf of the national government must be paid into the consolidated fund, except money that is set out in Article 206(1), which is money that is reasonably excluded from the fund by an act of parliament and payable into another public fund established for a specific purpose, and money that may, under an act of parliament, be retained by the state organ that received it for purposes of defraying expenses of that state organ. Our understanding of 206(1)(a) is that money earmarked and collected for a purpose must be paid over into a public fund established for that purpose by legislation. The housing levy cannot be paid over to a fund unless there is a legislative provision connecting the levy to the fund. Such a provision does not exist in Section 84 of the Finance Act. Similarly, Section 7 of the Housing Act establishing the National Housing Development Fund does not reference the housing levy as a source of funding. Section 7(3) of the Housing Act provides that, in part, that there shall be paid into the corporation and carried into the National Development Fund all monies as may from time to time be voted or appropriated by Parliament for payment into the National Housing Development Fund. There is no requirement that the monies collected by the housing levy are ring-fenced for for the Housing Development Fund or any other fund. Ring-fencing of stand by stating their purpose is of itself insufficient to underpin a legal framework for the intended purpose, contrary to the principles of public finance in Article 201 of the Constitution. The petition has also faulted the appointment of KRA to collect the housing levy. KRA issued a notice in the Noko newspaper stating in part as follows: Kenya Revenue Authority would like to inform members of the public that the Cabinet Secretary, Ministry of Lands, Public Works, Housing and Urban Development through a public notice dated 3rd August 2023 has appointed Kenya Revenue Authority as the agent for affordable housing levies. The petitioner's case is that KRA lacks legal authority under the KRA Act or any other legislation to collect levy. Under Section 5 of the KRA Act, provides the functions for the authority, and I set them out, and one of them is in performance. First, it is that the authority, under the general supervision of the minister, shall be an agency of government for collection of revenue, collections and receipt of all revenue, that in performance of its functions, the authority shall administer and enforce all provisions of written law set out in Part 1 of the first schedule, for that purpose to assess, collect and account for all revenues in accordance with those laws, and then 2, provisions of written law set out in Part 2 relating to revenue, and for that purpose assess, collect and account for all the revenues in accordance with those laws. And then it also states that the minister may, by notice in the Gazette, amend the first schedule. The import of the foresaid provisions in the KRA is that KRA is empowered to collect taxes under specific legislation set out in Part 1 and 2 of the first schedule. Under that act, the minister means the minister for the time being responsible for finance. What is clear from the reading of this provision is that the housing levy is not one of the taxes KRA is empowered to collect under Part 1 and 2 of the first schedule. Further, it is the minister or Cabinet Secretary for Finance who is permitted to amend the schedule to authorize KRA to collect a specific tax. The notice issued by KRA informing the public that it has been appointed by the Cabinet Secretary, Ministry of Lands, Public Works, Housing and Urban Development to collect the housing levy does not have any legal basis under the KRA Act. We have also looked at the Public Finance Management Act, which permits the Cabinet Secretary, in this case the Cabinet Secretary responsible for finance, to designate in writing persons as receivers of government revenue. It is therefore not possible for the Cabinet Secretary for Ministry of Lands, Public Works, Housing and Urban Development to authorize collection of a levy which, as we have held, constitutes a tax under Article 209 of the Constitution. We therefore reject the argument by KRA that it is entitled to collect housing levy merely on the ground that it is entitled to charge a commission on the amount it collects in accordance with Section 1610BA of the KRA Act. The authority to collect taxes must be issued by the Cabinet Secretary for Finance. As we have shown, the framework for the housing levy legislated by Section 54 does not meet the requirements of good governance, transparency, accountability as required by Articles 10(2)A and C of the Constitution. We must point out, though, that this court does not purport to prescribe any form of legal framework to be adopted by the national government, as this is a matter within its mandate. Our concern is that the legislation imposes the housing levy and sets its purpose and no more. How does an objective observer determine whether the purpose has been met or that the monies have been applied for the intended purpose when the manner of achieving that purpose has not been defined? The national government is required to demonstrate a rational connection between the purpose of that legislation and the means by which it is achieved. We hold that Section 84 of the Finance Act is not the kind of legal framework contemplated by Article 10, 201 and 210 of the Constitution. The petition has also complained that the housing levy applies to one category of the population, namely salaried workers in formal employment. They contend that this violates Article 27 of the Constitution, which protects equality and prohibits discrimination, and 201B1, which requires the tax burden to be shared fairly. They also complain that the housing levy amounts to double taxation because employees pay it in addition to income through pay-as-you-earn tax. Further, that it imposes an obligation on the employer to pay the levy despite the fact that under Article 30, Section 30, the employer is required to provide housing. The respondents countered this by stating that countered by stating that the county faces a serious housing deficit, which government is required to address in line with its responsibility to progressively realize the right to housing under 43B of the Constitution. Article 201 of the Constitution sets out the principles that guide aspects of public finance, and in particular, Article 201B provides that the following principles shall guide all aspects of public finance: that public finance system shall promote an equitable society, and in particular, the burden of tax shall be shared fairly, revenue rates nationally shall be shared equitably amongst the national and county governments, and expenditure shall promote equitable development of the country, including making special provision for marginalized groups and areas. Article 21B1 embraces the principle of fairness in taxation. It is acknowledged that in imposing taxes, there will be distinctions between classes of taxpayers, but the principle of fairness in taxation requires that this distinction must be justified as rationally related to a legitimate government purpose. This requirement prevents arbitrariness, which undermines the rule of law, and if distinctions are to be made, they must be a rational basis for them. We have looked at the responses by the respondents. Their key submission is that the national government enjoys the prerogative and latitude to impose taxes as a means of achieving the objective of realizing the right to housing. They did not answer why the tax falls upon employed formal workers as opposed to other taxpayers or non-taxpayers. In Okello and Another versus National Assembly and others, Odunga J stated that taxes need not look the same, and selective taxes may be applied to different actors for different reasons, such as to address distribution and equity. Hence, the tax need not be similar to another for it to be rational and discrimination. We add that for any legislation to pass the rule of law test, it must have a rational connection to a legitimate government purpose. Otherwise, the tax legislation would be arbitrary and unconstitutional. It's therefore the duty of the state to provide a rational explanation for the manner in which the tax is involved. In absence of a rational explanation for the manner in which the housing levy was enacted, we can only conclude that the respondents took the easy path of least resistance, as taxing employees. Informal employment is easier. It is also the respondent's constitutional responsibility to create a broad, efficient, fair tax system that complies with Article 201B1 of the Constitution, and the taxes levied against persons in formal employment to the exclusion of all other than formal earners to support a national policy without a clear justification is discriminatory, irrational, and arbitrary in violation of 201B1 of the Constitution, and therefore unconstitutional for those reasons. In the Court of Appeal, in Kenya Revenue Authority versus Waweru stated that explained the principle of unfair taxation under 201B as follows. On the issue as to whether the imposition of minimum tax results in unfair and contrary to Section 201, the threshold for fairness is ensuring that everyone bears their fair share of taxation and pays the correct amount, which is seen to be fair by vigorous pursuit of tax avoidance and evasion. The petitioners have assailed the housing levy on the ground that it will result in lowering salaries of judges, hence is in violation of Article 164 of the Constitution, as well as the commissioners and holders of independent offices, in contravention of Article 258 of the Constitution. These provisions that protect the remuneration and benefits are intended to safeguard the independence of judges, of superior courts, commissioners, and independent officers by insulating them from attempts by the political branches to influence them by reducing or threatening to reduce their remuneration and benefits. The petitioners have not demonstrated how the housing levy directly affects the salaries and benefits of protected officers, state officers, and how it violates Article 160 and 258 of the Constitution in that regard. Our reading of Article 210(3) of the Constitution is clear. It provides that no law can exclude or authorize exclusion of state officers from payment of tax by reason of the office of that state officer or the nature of work of that state officer. The petitioner's submission on that front also fails on the ground that the housing levy is a general tax that applies generally to all taxpayers and to us included. So having considered all the matters placed before us, we now conclude as follows, and this is what we state. The Finance Act is a money bill within the meaning of Article 114 of the Constitution. However, it contains some matter that would not fall within the purview or incidental to a money bill, although this does not change its basic character and substance as a money bill. The specific extraneous matters identified by the court pertain to amendment of the Kenya Roads Board Act 1999 through Section 76 and 78 of the Finance Act, amendments to the Unclaimed Assets Act by Section 87 of the Finance Act, and repeal of Section 21 of the Statutory Instruments Act by Sections 88 and 89 of the Finance Act. These amendments are extraneous to a money bill and are therefore unconstitutional. That under Article 220 and 221 of the Constitution, estimates of revenue and estimates of expenditure are part of the budget-making process. The estimates of revenue were included in the approved estimates contained in the Appropriation Bill and the Appropriation Act of 2023 as published in the Kenya Gazette Supplement number 87 of 15th June 2023 and 98 of 26th June 2023 respectively. We also find that the purport of Article 96.2 as read together with Article 114 is that the Senate is precluded from considering a money bill, which is only introduced in the National Assembly. However, in the matter of the Speaker, the Supreme Court held that it is necessary for the Speaker of the National Assembly to agree on the nature of the bill, any bill prior to introduction in any house. Consequently, the failure of the Speaker of the National Assembly to seek agreement with the Speaker of the Senate on the nature of the bill prior to its introduction in the National Assembly, in our view, does not vitiate the resultant act, as such concurrence is not a requirement under Article 114 of the Constitution. We find that there is ample evidence that the National Assembly conducted sufficient public participation in respect of the Finance Act. The National Assembly, having heard the views of members of the public and industry stakeholder on the bill, is not precluded from effecting amendments to the bill before passing it. There is no express obligation on Parliament to give reasons for adopting or rejecting any proposals by members of the public. Nonetheless, we think that in enhancing accountability and transparency, it is desirable that relevant committee, after conducting public participation, gives reasons for rejecting or adopting proposals received. We have looked at Section 2 and 21 of the Finance Act that amended Section 35 of the Income Tax Act to introduce digital monetization, and we find that this is a tax on income and it is permitted and it is not unconstitutional. The digital asset tax is a tax on income and it is not unconstitutional. The tax on winnings is a tax on income, and it does not violate the 4th Schedule, Part 2 of the Constitution, as it does not impair the functions of county government. We have also looked at Section 26 of the Finance Act that amends the 3rd Schedule of the Income Tax Act by introducing new bans, and these are matters that we do not consider unconstitutional. We've also looked at Section 33 of the VAT Act that introduces VAT on insurance compensation. We find that it does not violate Article 40, and it is not unconstitutional. We have looked at Sections 30 to 38 of the Finance Act, which amend Sections 5, 8, 12, 17, 34, 30, 34, 43, First Schedule, Second Schedule of the VAT Act, and we do not find them in violation of the Constitution. We also looked at Section 48 of the Finance Act, which amends Sections 2, 20, 28, and 14, First and Second Schedule of the Excise Duty Act, and by introducing Section 36(1)A and 36(A), and we do not find them unconstitutional. And we also have looked at the changes in tariff headings and rates under the Excise Duty Act, and we do not find them unconstitutional. And we find that the introduction of the Housing Levy amendment to Section 84 lacks a comprehensive legal framework in violation of Article 10, 201, 2010 of the Constitution. That levy against persons in formal employment to the exclusion of other non-formal income earners without justification is discriminatory and irrational and arbitrarily and in violation of Section Articles 27, 201, B1 of the Constitution. And flowing from those findings, we find as follows that, and these are our declarations, Section 76 to 78 of the Finance Act, amending Section 7 of the Roads Board Act, 87, amending Section 28 of the Unclaimed Assets Act, Section 88 and 89, repealing Section 29 of the Statutory Instruments Act are unconstitutional, null and void. That Section 84 of the Finance Act violates Article 10, 2BC, 27 and 201 of the Constitution and is therefore null and void. That an order is granted prohibiting the respondents from collecting, charging or otherwise the charge known as the Affordable Housing Act on the basis of the Section 84, and all prayers on the consolidated petition not specifically granted are dismissed, and this being a matter of public interest litigation, each party shall bear its own costs. And we thank all of you, all the councils who appeared before us, all the litigants who appeared before us, members of the public for keeping a keen eye on this matter, and we thank you all. It is part of your responsibility as citizens of our beloved country. Thank you.
May I please, sir?
Yes.
Yes. Please to my judges, first and foremost, I wish to thank you very much on behalf of all the colleagues who are here. 160 pages of a judgment was not a mean feat, and especially the reasoning we have actually gone through. Let's not comment now, because each side is carrying some joy, others are a little bit aggrieved. But on behalf of the third and fourth respondents, allow me kindly to confirm that we are aggrieved by the findings as regards the Kenya Roads Board Section 76 and 78, the Unclaimed Assets Act, the Statutory Instruments Act, and especially regulations thereunder, which possibly are in force today but may expire if that order is enforced, some of which are on revenue-raising measures, and Section 84 of the Finance Act, in which the housing levy has been declared unconstitutional, and a declaratory order has been made to stop the respondents from collecting the levies. Allow me to apply for a stay or a conservatory order for 45 days. In those 45 days, I urge you to suspend the operation of those particular findings in the judgment and any decree that may flow therefrom, pending the filing of a formal application under Rule 32.2 of the Mutunga Rules, as they are popularly known, and eventually under Rule 5.2b of the Court of Appeal Rules. The justification is as follows.
Could you go over that again, please?
Yes.
You're asking for?
A stay or a conservatory order for 45 days as regards the portions of the decision that has aggrieved the respondents, and in particular, it is a Kenya Roads Board, Section 76 and 78, the Unclaimed Assets Act, and the Statutory Instruments Act amendments, which have been declared unconstitutional. Also, Section 84 of the Finance Act, which has been declared unconstitutional as regards the housing levy, and an order has flowed therefrom, stopping the respondents from collecting the housing levy. So the reasons why we ask you for this is, first and foremost, especially for the housing levy, we have to make the necessary adjustments to the government procedure of taxation so that no party, no arm of government, no officer of the government is sued for contempt. Because that has been announced as from now, while it is in the public domain that in fact the levy is being collected as we speak. There may be also irreversible loss, and especially if, on appeal, this section is upheld. Because the reason is that this is a consumption tax. It's money that is being spent to exactly do what the amended Act states, which is to try and put up housing for citizens. There would be actually no prejudice on the part of everybody who has paid the housing levy. This is because, as the Court of Appeal observed in its ruling herein, civil application number E304 of 2023, any party aggrieved by payment to the government of these levies can actually get rebates for overpaid taxes and levies. So those applications can be made and the monies possibly will be refunded. Now, we also have another reason why we ask you for this, which is serious irreversible economic consequences in the operation of the arms of government, and especially when it comes to affordable housing. It is vitally important that this is preserved for a while as the government considers the next alternative after appeal or rectifying the law, the flaws in the law, as the court has identified that in fact there may be nothing wrong with the taxation itself. It's only that we do not have in place proper laws that are supposed to guide the policy. Therefore, with those remarks, I do pray that you grant a stay or a conservatory order for only 45 days, by which time the respondents will have taken a decision on how best to move, either to the Court of Appeal or to have enacted the proper legislation. Thank you.
No. We deal with the respondents first.
The respondents.
Kenya Revenue. Please introduce your name for the record.
For the record, I'm Mr. Ocheng Gaya. I appear for the Kenya Revenue Authority. My Lord, on behalf of the Kenya Revenue Authority, we'd like to seek a stay of the declaration with regard to Section 84 with regard to Housing Fund, the pronouncement, which is not in the finding but is in the body, as to Section 5.1 of the KRA Act with regard to the implementation of only laws with regard to the first and second schedule, because that pronouncement places us in a very awkward situation, because we not only collect the housing fund, but there are also other agencies. So we'll be seeking that pronouncement to be stayed. Why so? One, Kenya Revenue Authority has clearly captured in the judgment had issued a system adjustment and a public notice. And this system adjustment, those hearing from the bar, we are all aware that currently the pay is being collected together with the housing fund. That system adjustment will require time for it to be readjusted. Secondly, this judgment places a Kenya Revenue Authority at a position where it will be subject to suits for illegally collected funds, and two, will need a stay order to prevent refund claims which shall be made. Why so? Kenya Revenue Authority finds itself in a position where it can only refund taxes under the statute. These are being declared to be outside the statute, where we will be subjected to damages suit. In that regard, we will be seeking that we be allowed stay pending our formal instructions from the client on the best way forward. The petitioners will not be prejudiced in any manner, as rightly proved by learned counsel Senior Morungaru, Morugara, they can't claim refund. They can't claim refund from the relevant agency, which is the Ministry of Lands. They can't claim that refund from the Ministry of Lands, but we seek from our side that we don't have a mandate on and a remedy on how we shall recover these taxes, should the law finally be found to be proper. In that regard, I seek that you begin a 45-day stay with regard to Section 84 and that pronouncement with regard to KRA Act Section 51.
So, Soman?
Your Lordship, we will also be seeking stay as the Attorney General of the Republic to the declarations made by the court for the following reasons. Your Lordship, as relates to the declarations on the statutory instruments, it affects a plethora of regulations which we need to advise in order to comply with the very clear judgment of this court, various state agencies and government institutions on the effect that that has on them. Your Lordship, as relates to Section 84 of the Finance Act, as relates to the housing levy, we need time to advise the parent ministries on any commitments or contracts they might have entered into as relates to the collections made under the housing levy. We understand that the court has pronounced itself. We want to comply, and we will comply with the judgment of the court, but we are seeking, in order that we don't occasion any loss to the public, we be given that time to be able to sort those issues out. The third one is, Your Lordship, and it's a matter alive before you, we want the 45 days, and we pray you give us the 45 days in order to save judicial time. For sure, if that stay is not given, there will be a plethora of contempt proceedings against public officers for non-compliance with your judgment. In order to avoid that, we also want to make sure that we comply and we advise them on what they need to actually do. The third issue, Your Lordship, is we'll be seeking the advice and we will be consulting. Likely this is a matter that might head to the Court of Appeal on a 5-2B, so that we also save public time. We seek to be given that opportunity to also go to the court to be able to ventilate this matter. We think it's the court, Your Lordship, this court has done this many times, especially in matters of public interest litigation, to ensure that there is no piggyback and orders are not being lifted now and then. Parties are given time to save judicial time and to also to save the time that public officers spend on these issues. We do pray humbly you give us those 45 days. Thank you.
Senate, anybody? Okay, let's go to the petition. Anybody else who supports?
My Lord, my name is Omulama, once again David Omulama. I represent Kenya Export for Agriculture, Horticulture and Allied Workers Union, which is an interested party in the matter. Our view is that we associate my lords and my lady. We think that there could be some contractual obligations already entered into between government and certain stakeholders, because we've been seeing, we've been seeing activities around launching of housing projects all over the country in certain parts. And so in order for the government to have time to be able to deal with those contractual obligations, the 45 days sought for a stay are necessary so that things could be put into perspective and could be made right. Number two, we also think that listening to your judgment, the housing levy is not entirely unconstitutional. The reasoning behind your decision is that there are certain legislative measures which were not taken to anger the housing levy. We believe that that can be done because first and foremost, you set the fund, then you establish supportive legislation. So we think that is something, that's an option that respondents can look into, going forward. So 45 days unnecessary. We humbly pray that you allow that. Thank you.
I'll call petitioners in E181, one person in E181. E181, Okoiti Omtata, and the others. Who is speaking on behalf of those petitioners?
Your Lordship, I was holding brief for Senior Counsel Kutiende Amolo. Our submissions...
Introduce yourself.
My name is Evan Sugada. Our position is as follows. The application for stay is strenuously opposed for these reasons. A declaration of unconstitutionality cannot benefit from a stay order. We were with colleagues, some of my colleagues on the other side, when we dealt with petition number 080 of 2023, Eliud Karanja and others versus the Republic, the CAS case. A similar application was made and was rejected by this court. We asked the court to be guided by the reasoning of the CAS case to reject this application for stay on a declaration of unconstitutionality. The same was done in the Levy case. Instructive to note, the case went to the Court of Appeal. This is the CAS case. And the other side argued an application for stay in civil application number 314 of 2023. Similarly,
Number, please.
a civil application number 314 of 2023. Similarly, the Court of Appeal stated that a declaration of unconstitutionality cannot
Na mtazamaji, ni uamuzi uliotolewa kwenye mahakama kuu kuhusiana na sheria ya fedha mwaka 2023 wakisema kwamba matozo ya makao ama makazi ya bei nafuu ni haramu na ni kinyume na katiba. Tutakuwa tunarejea huko mtazamaji, tusikilize yanayojiri sasa hivi.
Who is in 211? 217?
My lords and my lady, my name is Cherongis. I do appear for the petition. The application for conservatory orders is vehemently opposed for the following reasons. One, what the respondents are seeking before this honorable bench is to extend illegalities. This honorable bench has made a declaration that the impugned Section 84 of the Finance Act is unconstitutional. This honorable court, having deliberated on the issue, made a declarations, and therefore it cannot revisit its decision at this juncture. Issue number 2, the respondents had sought 45 days to regularize and to put their house in order. And to some extent, the AG have sought to save the time of a judicial time. It's unfortunate that within 45 days, it's not sufficient to regularize the law. And the best way to do is to abandon such objective. The only resort they have is to appeal to the next higher court. We object the application. That is all, Your Lordship.
219.
Your Lordship, Ms. Adunga, holding brief for Mr. Umeto for the petitioners. Your Lordship, we do oppose that application for stay. The law on which the housing levy is founded has already been declared unconstitutional. That law cannot continue to apply. To apply it would mean that the court is reversing the decision that it has already made. That can only be done on appeal. So that law cannot continue to apply, and we urge this court to dismiss that application.
221 Law Society.
My Lord and my Lady, I join my fellow colleagues in opposing the application that has been made before you for a stay. And my Lord, I do not wish to repeat what has been mentioned. What is being sought is a stay, in our view, of a negative order. And my Lord, the courts have spoken several times, more than once, that that is an option that is not available when it comes to stay of its decisions. My Lord, we are finding ourselves in a position we found ourselves as petitioners when we were arguing for interim stay. And my Lord, at that particular time, the respondents were extremely loud that they would be capable of making refunds for any taxes that would be paid. And so, my Lord, at this point, to make an application to seek stay on the ground that they will have difficulties arising from this decision is speaking from both sides of the mouth, and we ask the court not to entertain that application. Lord, the housing levy is paid by employers and collected through the iTax system. As of this moment, all employers know that that tax should not be levied. And so therefore, they will not be able to deduct it and submit it to KRA. So there will be no difficulty whatsoever that will be occasioned by that decision. But my Lord, the other issue that is also important is that the iTax system is just a system for collection of taxes, for ease of collection of taxes. And so it must be configured to be able to collect those taxes. And my Lord, we all remember, because we were all here when we were urging the court to stay those decisions, that it took them no less than 1 day or 2 days to configure the system to collect those taxes. So I don't think that that would be a big issue. My Lord, it has been urged, my lady, that there are serious, irreversible economic consequences that are going to arise as a result of your decision, specifically on the housing fund. My Lord, those consequences have not been placed before you. It will only be proper that they have an opportunity to place that through a formal application so that we can also interrogate those grounds and the court can be able to make a reasoned decision on those matters. So as it is, my lord, the application that has been made before you is highly speculative. It is based on a speculation that there might be contracts that have been signed. And my lord, that is not a good ground for grant of stay. My lord, what would then be the effect if this court was to grant a stay of the decision that it has given? Well, the effect of that is that there would be continued collection of these taxes, despite a very clear and equivocal finding by this court that those taxes are unconstitutional. So, my lord, we are of the view that there is no probability that any of the respondents would be cited for contempt, because the housing levy is not a fund that is collected automatically by the government, but is a fund that is collected by the employers and submitted to the Kenya Revenue Authority through the iTax system. My lord, you've also been informed that there is a need for stay so that the Attorney General can be able to seek time to advise his clients on the import of the decision and the other government agencies with regards to the purport of your decision on statutory instruments. Well, Lord, we also find ourselves in the same position, that after this decision, we have to advise our clients on the effect of this decision. Some of our clients may actually be aggrieved with certain sections of this decision, and my lord, we do not think that that in itself is a good ground to give or grant stay in the interim. And so, my lord, we urge with tremendous humility that that application be declined. And my lord, I would want to also urge, as Mr. Ogada did urge you, because that is something, my lord, that we did submit on as a law society, that you do make an order for refunds of taxes that have been paid and collected. So then, my lord, you make it very, very easy for my colleagues to advise their clients and for us to advise our clients. Lord, thank you for that opportunity.
Azimio la Umoja Party.
My lady and my lords, with your kind permission, my name is Ochieng Oginga. Now, on behalf of Azimio la Umoja One Kenya Coalition, we do oppose the applications for stay. And I submit, firstly, that pursuant to Article 23, 3D, 23, subclause 3D, this court has exercised its powers to grant a declaration of invalidity of the laws. Now, I submit it will be contrary to this particular provision for this court again to issue an order suspending this declaration, because it will negate the object of this particular provision. Secondly, my lady and my lords, to stay the declaration of invalidity will be akin to this court sanctioning a continued violation of the Constitution. And my lords, the applicants have selectively chosen some of the reasons given as to why the housing levy has been suspended and declared invalid. And the court will note it has observed that the levy is not sanctioned in any legal framework. It is being illegally collected by the Kenya Revenue Authority, and it is also discriminatory. My lord, so that these, among other reasons, are valid reasons sanctioned by the Constitution upon which an act of parliament can be declared unconstitutional.
Na mtazamaji, ni masuala yanaendelea kwenye mahakama kuu baada ya uamuzi wa mahakama kutoa uamuzi kuhusiana na sheria ya mwaka 2023 ya fedha, ikitaja baadhi ya sheria katika mswada huu ama katika sheria hiyo kuwa ni kinyume cha sheria, ikiwemo vile vile ile sheria ya matozo ya makazi ama makazi ya bei nafuu, yani housing levy. Na ni baadhi tu ya mambo yanaendelea hapo, tukiona kwamba mawakili kwa upande wa walalamishi wakiwa wanapinga lile ombi la kupewa kwa siku 45 kutoka kwa upande wa serikali ili kuwezesha nafasi zaidi kabla